Speaker.
Call. Charles Cheval, 5-minute call.
Thank you, Mr Speaker. Mr Speaker, I want to begin my contribution by congratulating Kennedy Graham on bringing this measure forward and indicating that the New Zealand Labour Party will support sending the bill to Select Committee for further consideration. I think this is probably the first occasion on which a member's bill has triggered a Law Commission report, and that's probably another reason to indicate that this is a bill that has some significance attached to it. The reason that my colleagues and I have decided to support the bill to Select Committee is that we do believe very strongly in the importance of the principle of the open administration of justice. And this is especially the case since we took responsibility for our own final appeals, repatriating that jurisdiction from the Privy Council and reposing it in the court that sits opposite Bowen House today. But having said that we will support the bill to Select Committee, it is important to recognise that the bill raises some very serious constitutional and other legal issues. Those issues are going to need to be very carefully canvassed in the Select Committee, and the commitment from the Labour Party to support the bill is to ensure that that discussion can occur in the appropriate forum. The Law Commission report does set out some of those concerns, and I might just mention one or two of them now. First of all, there are real problems in conducting a comparative analysis, as we would normally do, with jurisdictions that we like to compare ourselves with. There is no comparable proposal or actual register in the United Kingdom, in Australia or in Canada. And that applies in respect of the federal and state or provincial jurisdictions where that is a relevant factor in those jurisdictions. So there's really nowhere that we can look to in terms of those jurisdictions that we normally like to consider when we think about whether or not a particular intervention would work in New Zealand. I think the previous speaker mentioned the United States. There has been an attempt to codify judicial obligations as to disclosure of potential conflicts at the federal level there. But that has raised some real problems which we will have to confront when the Select Committee discussion that I mentioned earlier occurs. Chiefly, who polices? Quis custodes ipsos, I think, is the maxim. The judges are going to have to themselves take responsibility in the end for the accuracy of any register that might come into being. And there have been real problems around the timeliness, accuracy and completeness of disclosures under the American system. So that is a warning, I think, as to the potential fate of a register in a jurisdiction such as ours. There are other issues that will need to be considered and are referred to in the Law Commission report. What should the scope of a register of judicial interests be? Should it apply to judges only, or to all the quasi-judicial tribunals that sit part-time across the country? What sort of detail should be required in the register? Should it be as for our standing orders, or should it be a more scant provision? How often should the register be updated? Should it be on the acquisition of any new assets, or should it just be an annual or even a less frequent updating required? Should it apply to spouses, children, related parties, or simply to the judicial officer, him or herself? And finally, and most importantly, sir, should we as a parliament be seeking to impose upon the judiciary these sorts of requirements? My own view is it would be much better if the courts were to do this sort of thing themselves voluntarily. And I suppose it would be my hope that we could come to a position where this sort of debate encouraged that to occur. To me, sir, that would be the ideal position, Meanwhile, we look forward to the Select Committee debate.
Point of order, the Honourable Paula Bennett.
I seek leave for